Good evening, everyone. So, this is the next part of unit. Just hold on for a second. Unit number 4, and it will cover intellectual property rights. So, let us understand what do you mean by IPR first. There are two kinds of property: property made by mind and property made physically. Property made physically, like buildings, like land is there, like these are physical properties. And some of the properties are made by a specific mind, a well crafted, designed, well thought mind, and those properties are called as intellectual property. For example, when you write a book, then what kind of property are you creating? We are creating intellectual property. Writing a book is an intellectual property. For example, you're making a design, then what kind of property are you making? A very peculiar design, then what kind of property are you making? You are making intellectual property. So what is intellectual property? Intellectual property refers to creation of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. IP is recorded, IP is protected by law, by, for example, patents, copyrights, and trademarks, which enable people to earn recognition or financial benefit from what they invent or create. By striking the right balance between the interests of innovators and wider public, the IP system aims to foster an environment in which creativity and innovation can flourish. Just imagine you wrote a book and someone makes a photocopy of it and distributes among the people. Then how will you sell your books? So it is very important to protect your intellectual property. Intellectual property rights, a right that is had by a person or by a company to have exclusive right to use its own plans, ideas, or other intangible assets without the worry of competition, at least for the specific period of time. These rights can include copyrights, patents, trademarks, and trade secrets. How many? So say whenever someone makes, for example, a film is made, a movie is made, that is also an intellectual property. That is because it is made by made made out of some creative venture. And now the person who is making a movie, just imagine several copies in CD is made and it is distributed among the viewers. Will he earn money? Will he be able to encash whatever innovation he has made? And will anybody will be encouraged to make these innovations? So it is very important to protect their rights, and when at least they should get some money out of it. At least they should be paid for their intellectual property. At least they should be able to enjoy that for a particular period of time, not maybe not for the whole life, or maybe not for the infinity, but yes, up to certain time there should be ban on making copies, etc. Now, what are the forms of IPR? Copyright. Copyright means when you make a copy of something. Patents patents so when you file a patent. Trademarks, these are marks like used in brands as well. Industrial designs, the designs made for industrial purpose. Geographical indications, there are several things you would have come across these geographical indication of coffee has been given some geographical indication. And so geographical indications, for example, if you which is a place which is famous for this Peda, Mathura. So Mathura should be given geographical indication. Otherwise, everyone will copy their Peda and they will sell it. Integrated circuit layout design. So these are IC circuit layout design. If someone designs some peculiar IC circuit layout, then that also need to be promoted. Then trade secrets. If there are any trade secrets, then they are also to be promoted. So these are mainly 7 types of IPR and related laws. So copyrights, Indian Copyrights Act 1957, Patents, Indian Patents Act 1970, Trademarks Act 1999, Industrial Designs, the Industrial Designs Act 2000, Geographical Indications, the Geographical Indications of Goods Registration and Protection Act 1999, Integrated Circuit Layout Design, the Semiconductor Integrated Circuit Layout Design Act 2000. So these are the also acts related to IPR. So you need to remember what are the forms of IPR and related laws. Now, intellectual property rights, what are the features and importance? Salient features of IPR. First of all, they are territorial. IPR is always territorial. It is related to some territory. Then giving an exclusive right to the owner. Why intellectual IPR is required? Because it gives exclusive right to the owner to exploit his innovation to so that it is not copied, and he is getting maximum out of it. Assignable, it can be assigned. Owner can assign it. It can give its rights to someone else. He can give his right to someone else. Independence, their independence of exploitation. There can be, for example, if someone is, uh, for example, having right to copy certain copies of some book, then they've got the independence to copy those books. Subject to public policy, definitely. It is subject to public policy. Any IPR cannot be against public policy. It is related to public policy. Public policy means governmental policies. Divisible, fragmentation, it is divisible. There can be an instant when copyright, when the rights are divided between two people. There are instances. Now let us find about importance of IPR. First one is providing guarantees regarding the quality and safety of the product. So it is very important to provide guarantee regarding the quality and safety of the product. For example, whenever if you would have seen, let us take an example of Nike. So when Nike is made, then for example, it is copied. As you already see that many people who copy Nike, are they able to make Nike of same quality? No. And consumer, when he is buying, then he will think like he is buying Nike, and he'll be unfortunately he will be buying quality product of inferior quality and of less safety. Then enable indirect exploitation. So it will enable indirect exploitation. Because why enable indirect exploitation? Because sell the person who made the design will not sell it for low cost, and copies can be made on it can be sold of low cost, but the person who is making it will not be made of low price, and he will not price on the lower end, and that will lead to indirect exploitation of consumers. Cost free mechanism, it's a cost free mechanism. You don't need any charge or anything else. Yes, definitely there is some fees, but IPR is a cost free mechanism. Dissemination of technical information. Of course, through IPR, you are disseminating technical information, because when you're making any patent or designing anything, then you are definitely giving it some technical superiority or technical peculiarity, and then you disseminate that technical information to the people. Facilitating technology transfer, it does facilitate technology transfer. Technology can be easily transferred by just moving the IPR. For example, if there's some machine made in US and India want to make that same machine, then it can just get the patent done in its name, or transferred in its name, or buy the patents, and then definitely can make that technology over here. Open source relied on IPR. There are various open source where you are free to download it. You can also take printouts, and those open source rely on IPR, because if someone violates that IPR, someone makes copies, etc., then they are punished. Enhance profitability. It enhances profitability of the people, and it also promotes innovation. To face competition, definitely it helps companies to face competition, because they can invest in research and development, and they can design their own patent and get it patented, and then they can of course go ahead of their competitors. Collateral to obtaining financing. Obtaining you won't believe, but yes, patents, copyrights, they can be kept as security for obtaining financing. They can be kept as security. So they can be kept as collateral for obtaining financing from the banks and financial institutions. Now let us understand these one by one. What is copyright? Copyright is a form of intellectual property that grants the creator of an original creative work an exclusive legal right to determine whether and under what conditions this original work may be copied and used by others, usually for a limited term of years. Now, importance of copyright is creation of public record, right to sue for copyright violation, acts as clear cut evidence. So, it acts as clear cut evidence, your copyrights. Recovery of damages. If someone copies your copyright without your permission, you can recover damages. Protection against import of copyright products. So, if something is you cannot import copyrighted products just without obtaining any copyright. Types of work covered: literary work is covered, dramatic work is covered, musical work, artistic work, cinematographic work, sound recording, computer program. These things are covered under copyright. So these things are copyrighted once they are made. Rights conferred by copyright. First is statutory right. Statutory rights means legal right to use that copy. Economic right, to get money out of it. Moral rights, definitely. If someone is if you have made your if you have copyrighted something, then nobody can copy your copyright, and you get your moral responsibility rights. Copyright is a negative right. Definitely it is a negative right, because it forbids to make a copy. You cannot copy anything without getting permission. Now, types of term for copyright. For how long copyright remains? It is 60 years. So once copyright is obtained, you cannot copy that particular creation for 60 years. So you would have come across various movies which are remade after 60 years, because then you don't need to obtain copyright. Otherwise, if you want to remake any movie and before 60 years, then you'll have to obtain copyright from the person who made it. Now, trademarks. A trademark is a recognizable sign, design, or expression which identifies products or services. Some logos, etc., identifies products or services of a particular source from those of others. Although trademarks used to identify services are usually called service marks. So, trademark is related to goods and service marks is related to services, and it is like logo we make. So, whatever logo, etc., which denotes some recognizable sign, design, or expression which identifies products or service. Then, if you remember that Hyundai has different logo, Toyota has different logo, and these are called as trademarks on the service marks when service is involved. And trademark owner can be an individual, business organization, or any legal entity. A trademark may be located on the package, a label, a voucher, or on product itself. For the sake of corporate identity, trademarks are often displayed on companies' building. For example, SDFC buildings, there they display their own logo. It is legally recognized as a type of intellectual property. So it is a intellectual property. Now, types of trademarks. Non-conventional trademarks. So these are modern trademarks where they have different kinds of logos, and they old kind of, like, they make some logo or some trademark is there. Motion trademark, moving kind of trademarks, and service trademarks. So these are trademarks related to services. Collective trademarks, these are when you, for a group of product, you make one trademark. Certification trademarks, for example, ISO, etc. So these are certification trademarks. Then well-known trademarks. So there are various well-known trademarks which are this Whirlpool is there. So these are well-known trademarks. This is a type of trademarks we have. So non-conventional trademarks, newer trademarks. Motion trademarks, there are various moving trademarks, like which can be moved from one product to another. Then service trademark, trademark related to services. Collective trademark, when a group of goods or services, they are given same trademark, like TCS is offering their trademark. Offenses and penalties related to trademark. Whenever you falsify any trademark, you make false design, logo, etc. Falsely applying trademark, when you falsely apply that some already existing trademark. Making or possessing instrument for falsifying trademark. So if you have any instrument even to falsify any trademark, that is also a crime. Applying false trade description. Applying false indication of country of origin. For example, you are indicating false country of origin. Your product originated in Sri Lanka and you are naming it as Nepal. Then also tampering with indication of origin already applied to goods. So there are various origin which are applied to goods, and if you are tampering with that, then also that is a crime. Then selling goods falsely marked. So if there is some good and you are selling, you don't know about that good whether it is falsely or truly marked, but you are selling some copy or something, then also it is a crime. Removing piece goods. So if you remove some piece goods, that is also a crime. Remove some goods out of it. Falsely representing a trademark as registered, though your trademark is not registered, but you are falsely representing that to be a registered trademark. There's some 10th point, it is lost, so let us leave that part. Now patent is a form of intellectual property that gives its owner the legal right to exclude others from making, using, selling and importing an invention for a limited period of years in exchange for publishing and enabling public disclosure of the invention. Patent is a form of intellectual property that gives its owner the legal right to exclude others from making, using, selling, or and importing an invention. So you have made some invention. Now you want to keep it for yourself. You don't want anyone to make a copy or use or sell that particular invention for a limited period of years. Then you can do it through patents. Now, what are the importance of patent? Right to restrict others. Right to exclusivity. Exclusivity means I will sell my own product. You don't sell my product. Patentee can legally sue for violation. If something violation happens, then you can sue for your product. Patentee earns by selling and licenses, so you can give your licenses and you can earn. A negative right to inventor. So if you're inventor, you can restrict the flow of your goods. Encourages incremental change, definitely. Territorial in nature, it is related to some territory, definitely, because if in case you made some important thing, then you want your product to move to different territory, then you will have to give your patent or give your patent rights to someone. Promote technological innovation, safeguards creation and safeguards innovation related to industry. So these are the profits, these are the importances of patents, that it promotes technological innovation, it safeguards creation and safeguards innovation related to industry. Now, what are the conditions of patentability? How, when patent is given, there should be novelty, new product, new design should be there, new invention should be there, non-obvious or inventiveness. You cannot just say like I invented this. There should be non-obviousness as well. Obviousness means something which is obvious should not be it is not an invention. Then useful and industrially applicable, it should be useful and it should be industrially applicable, then only it will be recognized as patent. Now, right of patentee, exploitation of patent, he can exploit his patent. Licensing the patent to others, you can license your patent to others. Assigning a patent to others, you can assign your patent to others. Surrendering the patent, you can surrender your patent. Then suing for infringement of the patent, you can sue anyone for infringement of patent if it happens. Next one is industrial design. Industrial design is a process of design applied to products that are to be manufactured through techniques of mass production. So there is some innovative design or some new design you have made, that is also your intellectual property. Creative design in business. Creative design in business. Customize product to appeal to specific market segment, then also that is your design. Create a new niche market. When you create your new niche market by designing some new product, that is also your industrial design. Strengthening brands. When you strengthen your brand and you made something as brand, that is also your industrial design. And merits. What are the merits? It imparts value to the product. Something becomes brand, then it becomes it gives value to your product. It generates profit, it promotes healthy competition, it leads to economic development. So these are the merits of industrial design. Let us go for geographical indication. A geographical indication is a sign used on the product that have a specific geographical origin and possess qualities or a reputation that are due to that origin. So these are given when any product has having some specific geographical origin. For example, Mathura ke pede, Agra ke pethe. Then you can go for this Karnataka's coffee. These are geographical indication. The products are having geographical indications. Assam tea. In order to function as GI, a sign must identify a product as originating in a given place. In addition, then you give a sign and you recognize that sign as GI, that is geographical indicator. In addition, the qualities, characteristics or reputation of the product should be essentially due to the place of the origin. Since the qualities depend on the geographical place of production, there is clear link between the product and its original place of production. So it is very important that in the box or wherever it is mentioned, you should mention clearly what is the original place of production of that good, and what is the term of GI, for how many years you get protection if you register for GI, 10 years. Now, integrated circuit and layout design, topography. It means a product in its final form or an intermediate form in which the elements, at least one of which, is an active element, and some or all the interconnections are internally formed in and or on a piece of material and which is intended to perform an electronic function. So IC circuits, you already know about IC circuit. It is made in a pad. You would have come across IC circuits in laptops, etc., where one motherboard is there and there are various things done on that motherboard. IC is integrated circuit, and an electronic circuit is an electronic circuit in which the elements of the circuit are integrated into a medium and which functions as a unit. A layout design of an integrated circuit refers essentially to a three-dimensional character of the element and interconnections of an integrated circuit. Registerability of layout design. A layout design which is not original has been commercially exploited in India or in convention countries, or not inherently distinctive or distinguishable from any other registered layout design, cannot be registered as layout design. So it should be original. It should not be commercially exploited in India or on or in a conventional country, and it should not inherently distinctive or distinguish. It should be inherently distinctive and distinguishable from something registered. So in novelty is very important, and in order to claim protection for layout design, it is mandatory that it should be registered. So it is very important to register your IC. Duration of protection. The registration of layout design is valid only for the period of 10 years from the date of filing an application for registration or commercial exploitation in any country, whichever is earlier. So duration of protection is 10 years. Infringement of layout design. In addition to civil remedies available, an infringement of layout design is considered to be a criminal offense in India. Infringement of registered layout design has been made punishable under the Indian Semiconductor for Integrated Circuits Layout Design Act 2000 with imprisonment of up to 3 years or fine 50,000 rupees up to a maximum of rupees 10 lakh, or with both. Now, trade secrets. A trade secret is a type of intellectual property in the form of a formula, practice, process, design, instrument, pattern, commercial method, or compilation of information not generally known or reasonably ascertained by others, by which a business can obtain an economic advantage over competitors or customers. So these are some trade secrets which you keep. Some specific formula like Coca-Cola or Pepsi, they have their own formulas. Then practice, process, they can keep that as secret. That is a trade secret. Trade secret is any practice or process of a company that is generally not known outside the company. Information considered a trade secret gives the company an economic advantage over its competitors and is often product of internal research and development. So they make some research and development and then they develop some secrets and they keep it. And those secrets are protected by law. Now, what are the features of trade secrets? Can cover non-patentable data, definitely. Must be secret. Have definitive duration. Definite duration is to be there. Can be non-exclusive. It can be non-exclusive. It can be reverse engineered, definitely, because it is through internal research and development, so it can be reverse engineered as well. Importance of trade secrets: only alternative for non-patentable. So if you have something which is non-patentable, then definitely you can go for trade secrets. You can make your own formulas, etc. Then provide long-term competitive advantage. Definitely it does provide competitive advantage, because here you have your own formula, secret formula, and you are making your product according to that formula. And free of cost, because you are making your own research and development, and you are then making your trade secrets. Then tools to protect a trade secret. What are the tools to protect? Agreement with the employees. If you make an agreement with the employees to protect trade secrets. Trade secret policy. You have trade secret policy that nobody can disclose a trade secret whosoever is working. Non-disclosure agreement. You cannot disclose. That agreement can be signed. Sufficient documentation and records can be kept for for keeping the secrecy, and security systems should be maintained to maintain the trade secrets. So with this we come to end of fourth unit. I hope you enjoyed. It was a bigger unit, and but I've covered everything in PPTs, so you can just go through PPTs and find yourself in a comfortable position in examination. Thank you.